All right, and it looks like we're starting to get people logged on. So I just want to thank everyone for joining us today. I'm going to do a really quick introduction so that Tina has a ton of time to answer questions. My name is Cece Mortar, and I'm the programs manager for the Steamboat Springs Chamber. I want to start by giving a quick shout out to our business education series sponsors, Mountain Valley Bank, UC Health, Northwest Data Services, Air Academy Credit Union, and the Colorado Housing and Finance Authority. They make these free events possible, and I hope they're helpful. A couple house cleaning items. Please switch your chat to everyone so that everyone can see your chat. And we ask that you put your questions in the Q&A at the bottom of your screen. We'll be taking questions about halfway through and then again at the end. So just put them in as you think of them, and we will touch on them when we get to those time frames. I couldn't be happier to welcome Tina Harkness back for the third year of this event. It's a membership favorite. Tina is a general counselor at the Employers Council. She represents employers in a wide variety of employment law matters. She's a frequent speaker on training topics, including legal issues, managing employees, harassment prevention, civil rights, managing employee medical issues, diversity, and other subjects. The Employers Council is a great place for all of you to find legal training and HR resources too, so keep them in mind if you need help with your current business or growing. Thank you for being here, Tina. I'll let you take it away.
Thanks, Cece. And Cece's going to run my slides today, and I will be sending them to her after this session so she can distribute them. So for those of you who are excited to have the slides, or eager to have the slides, you will get them from the chamber. So happy to be back for our 2024 employment law update. I always enjoy keeping up with what's going on federally and at the state. I would say we've got some important things that we'll talk about federally. One biggie, which will be the overtime threshold change. So we will spend a little more time on that. And then at the Colorado session, not as many fireworks on the employment law side, which I hope you're grateful for this session, as in the last few sessions, but still some stuff that's going to be important for you all to know. So we'll dive into the federal, and then as Cece said, we'll take a break after the end of the federal update to see what questions you have on that material. So just the necessary, the copyright and the disclaimer, just so you know, I'm not your attorney, you know that you need your attorney to advise your organization on how any of this stuff affects you. If you have general questions, of course, I'm happy to take those. But specific questions about specific individuals particularly are best for your human resources or your personal company legal advisor. So let's dig in, starting with one of the Supreme Court decisions from this term. And I mentioned this in the blurb. We occasionally do get employment law cases that find their way up to the Supreme Court. And discrimination cases, the law is pretty well settled, but occasionally those cases make their way there. And this is one of them. So this involved a police sergeant who worked for the city of St. Louis. She sued, alleging that her forced transfer out of the intelligence unit and denial of her later transfer request back to that unit was illegal sexual harassment. And that case went up to the Eighth Circuit Court of Appeals, which is not our circuit. We're in the 10th Circuit, but went up to the Eighth Circuit Court of Appeals, and they dismissed her claim, saying that the transfer didn't cause her some materially significant disadvantage. It was only minor changes to her working conditions. So in specific, she no longer worked with some high-ranking officials on departmental priorities in the intelligence division. She lost access to taking an unmarked take-home vehicle home, and she had a less regular schedule than she did in the intelligence unit, including some weekend shifts. Now, the Federal Circuit Court of Appeals across the United States, they deal with these cases more regularly than the Supreme Court. Some had said we only need a small amount of harm shown. And the Eighth Circuit was among the courts that had said, got to show a materially significant disadvantage. So the Supreme Court took this case to resolve that split amongst the federal circuits. And kind of in a little bit of a surprise verdict, the Supreme Court went with the lower standard. And they basically said, if a worker can show that there's some harm, even if it's not significant harm, that will be enough for a civil rights discrimination claim here based on sex discrimination in a job transfer claim. So this raises the stakes for employers, right, in those transfer decisions we make about employees, because we might not think they change that much, but the employee might think they change a lot. So that is going to be the new standard going forward. Can they show some harm, even though it's not significant harm? So let's go on to the bigger news, which is the Department of Labor has finally issued final rules on raising the federal overtime threshold. So the Fair Labor Standards Act has been with us since the 30s, and it has set in its existence a threshold below which employees cannot be considered exempt from overtime. So that threshold obviously has changed over time. The last change was made by the Trump administration in 2017 and placed the minimum salary required for exempt employees at $684 a week or $35,568 a year. So this threshold is what's currently in place. It is going to change very soon. July 1st is creeping right up on us in 2 stages. So the July 1st stage change will be to jump that up from $684 per week to $844 per week, or $43,888 dollars per year. So that's a jump. The second jump would follow in January of 2025. And that is a more significant jump, as you can see, raising the threshold to $1,128 per week, or $58,656 per year. So the change applies to all employers covered by the Federal Fair Labor Standards Act, which is pretty much all employers. There are some very small employers that don't operate in interstate commerce that might fall below coverage, but really it's all employers, public and private, for-profit, nonprofit. The other piece of the regulatory change would set up a automatic update every 3 years. So that would begin in July 1st of 2027. And that would be calculated based on current wage data. So what the Department of Labor has done is it's split the country up, I think, into 4 quadrants. And they've looked at the lowest income quadrant, which is typically the Southeast in the United States. And they have calculated the salary threshold based on that, on those kinds of numbers. So that is, I think, the system they would follow going forward. Now, for those of you who have any employees who are exempt under the highly compensated employee exemption, that has a different salary threshold. As the name implies, it's much higher. And that is going up as well in 2 stages on July 1st, 2024, and again on January 1st, 2025. So you'll want to look at those numbers. I find that there are very few employers that are using that highly compensated employee exemption. People have to be making 6 figures at minimum, and they have to be performing some exempt functions. Now, before we move on, I should mention that this applies to the executive, administrative, and professional exemptions under the Federal Fair Labor Standards Act only. There is an outside sales exemption that this does not apply to. And there are some other more granular exemptions under these. So motor carrier, there's retail and service establishment exemptions. Those kinds of things are not affected. And for professional employees, there are exceptions for doctors, lawyers, and teachers, which are also not affected by this change. Now, you can use non-discretionary incentive payments to meet these thresholds, to satisfy up to 10% of this threshold. So it doesn't have to be all be salary. Up to 10% of it could be an incentive if you have incentives built into your compensation system. But again, they have to be of the non-discretionary type. So they are planned, they're based on, achieving certain objectives over the course of the year. They're pre-announced to employees so they can work towards that goal. They're not the on the spot, we have some extra money and we want to share it with our employees, discretionary incentives that we might provide. And if you get to the end of the year and you have one of those base plus incentives programs and the employee doesn't quite meet the threshold, then you actually can make a catch-up payment. So say they only got to 42,000 by the end of 2024 instead of the 43,880. You could, in the first pay period after July 1st, make a catch-up payment. So you can fix it if your incentive program, if the employee doesn't earn enough under your incentive program. Same thing at the end of the year, and in a year to follow. So moving on, I just want to make sure everybody is aware that there are actually 3 tests for exempt employees. It's not just salary. That is one. And if you fail that, then again, you cannot have this person be exempt from overtime. That's what we're talking about here, is an exemption from being paid a premium for working under the federal law over 40 hours a week. So this is one of the tests. The other tests are that the employee has to be paid on a salary basis. So again, there are some exceptions to this, but salary basis means they get a regular recurring amount that's not affected by the quality or the quantity of their work. And yes, that language is in the Federal Fair Labor Standards Act. Now you can make certain deductions from exempt employee pay, but they are limited. So that's the paid on the salary basis portion. And then the hardest test to meet is really that third one, where the employee has to primarily perform duties that the Department of Labor defines as fitting an exempt executive, an exempt administrative employee, an exempt professional. And those tests can be rather lengthy. I would just summarize it for you here to say executives aren't necessarily somebody we might consider executives today, although they would fall into this category, but it goes all the way down to people who run portions of your business to manage those, and people who supervise your employees as their main function of their job. So that is a big category. Administratively exempt employees is a smaller group, but these are your high-level internal decision makers. So that's your executives as well. So they might double up on these exemptions. But there may be some other folks that also make high-level internal decisions, not necessarily about your product or service that you provide, but about the running of that business. And then professionals is another broad category. There's actually 3 subsets to the professional exemption. The learned professional is the person who has a degree that's required to do their work. And it's typically a field of science that is the degree. But this is your engineers, your architects, again, your doctors, your lawyers, your nurses, those kinds of folks that fit that category. There are also creative professionals who may not have a degree, but their jobs involve, excuse me, a high level of creativity. And they're typically in the fields of arts or music or dance or those kinds of things. So that's a narrow section. And then computer professionals. So obviously computers weren't around in the 1930s when the Fair Labor Standards Act was passed. But when they did come around, there were some people who not necessarily degreed, but were very skilled in the design of hardware and software and those kinds of systems, where Congress decided we need to add an exempt status for those folks. And that's one of them. And here you'll also see the outside sales. Again, that is not affected. Is coach under the professional category of exemption, not specifically Blair. So that would, because a degree may or may not be required for that role. It is going to depend. So that's good. You're going to want to talk to your human resources department or your attorney and look at the full position there. So I also want to note that there were no changes to the requirement that the exempt employees be paid on a salary basis, and there were no changes to the duties tests, which is good. Yeah, they're not easy tests to meet, but at least we know them. So we don't have to figure out changes to those at the same time. We've kind of been hoping that the Department of Labor doesn't mess with the duties tests too much, because they tend to make them more complicated when they've changed them in the past rather than simplifying them. And I also want to note that the employer has the obligation to prove that the employee meets all 3 of these requirements. It's not assumed. So you're going to have to make a showing if there's ever a question of, is this employee exempt from overtime on all of these bases? And if you can't, then that person is non-exempt and needs to be paid overtime, and probably some back pay overtime. Some other things to note on the next slide are that some states have their own overtime thresholds. So those of you who are private employers in Colorado have been saying, yeah, but Colorado's requirements are there, Tina. And yes, you're absolutely right. And currently under Colorado's scheme, or Colorado's overtime threshold, private employers, for-profit and non-for-profit private employers currently are paying exempt employees $1,057.69 per week, or $55,000 per year. And those of you who are subject to those requirements know that those get updated annually by our Colorado Department of Labor and Employment based on Denver Boulder numbers. And it's usually around the end of the year, usually October, that we get the new pay calc order. We're at the point where we're at the end of 3 steps of staged increases, and now they're going to start calculating. So you're not going to be affected by the first jump in July because that's under the $55K you're already paying your exempt employees, private employers, but you will be affected potentially by the January 1, 2025 jump, which is up to 58 and some change. So that is above what we have now, and we'll see if it's above the published new threshold that they calculate this fall. So we'll just have to see. So the biggest impact of these overtime jumps is going to be on you public sector employers and the nonprofits that are funded by public monies, which isn't that many. It's usually like Head Start programs, things like that, that are connected to public school districts and those kinds of things. But if you have questions about that, and you have people that are below that threshold, you're going to want to get ready. Now I'm saying get ready because you probably remember, if you've been doing this for a while, that the Obama administration attempted to change the overtime threshold in 2014, I believe, to almost 48,000 a year. And that was blocked by a federal court in the Fifth Circuit 1 week prior to the change being implemented. So you guys are planners, just like me. You were all ready to go, and some of you had shifted people to the new threshold and then found out, nope, it's not gonna be 48. And when the Trump administration came in, they passed a lower threshold, which is the one we have now of 35,000 a year. So get ready. Look at your employees, look at the ones who are currently classified as exempt who would be below those thresholds. Now you might have to make the July jump because that's just a month away. And that one is just going to creep right up on you. But there is a lawsuit challenging the change to the overtime threshold in the same circuit that blocked the Obama era change. So making, as you could imagine, similar arguments. So we'll see. I mean, that July 1st jump, if you are below that with some of your people, you're either going to have to raise them up to that 43,000 number, or make them non-exempt. We'll talk about what that means next. Or you will need to, you'll need to do one or the other of those things. Raise them up to keep them exempt, or drop them down to non-exempt and make some other changes. But we're watching that legal challenge. It'll be big news if this gets blocked as well. But we're not expecting that July 1st jump to be blocked, because one, it's coming up too quickly, and two, the Department of Labor used the same process and calculation that the Trump administration used for that stage for the last salary increase, which did go through and did not get blocked by federal courts to raise it to 35,000. So it's the January 1st jump of 2025 that's more of a stretch and a bigger jump that we're thinking could be blocked. All right. If you have to change somebody from exempt to non-exempt, of course, overtime pay is required. And in federal, I mentioned that is required after 40 hours in a week of hours worked. We also have in Colorado our state overtime requirements that your employee will be subject to if they don't meet the requirement to continue to be exempt. And we have our state rules for that. So just know there's state overtime. You don't have to pay both, but you may have to do both calculations to determine what results in the greater payment to that non-exempt employee. Also, time records are required for your non-exempt employees. So that sometimes is the biggest pain point, where now this person has to submit a timesheet or log in and clock in when they come in and clock out on their lunch and clock back in and clock out for the day and all those things that interestingly enough, that can sometimes be the most resisted part of changing status. And again, you have options for how you keep time as an employer, but it is your obligation to have those time records for your non-exempt employees. Also, non-exempt employees sometimes get less flexibility in their hours or their work schedule because of that concern about having to pay an overtime premium if the person works over a certain threshold. And some benefits. I don't think this is as much anymore, but sometimes employers will have benefits that are different based on exempt or non-exempt status. I don't see that as much, but if you do, then you're going to want to look at that. And then non-exempt employees are going to be subject to Colorado's meal and rest period requirements as well, which are not insignificant. So moving on from wage and hour, also in the federal realm, the Equal Employment Opportunity Commission has updated its workplace harassment guidance. This is the first time in 25 years that they've done that. They tried to do this in 2017, and their guidance was never finalized because basically they couldn't agree on what they needed to include to update the guidance. So this is their first opportunity, apparently since 2015, with the Bostick decision to incorporate sexual orientation and gender identity into the protections under sexual harassment. That is, of course, a Supreme Court decision that that said that federal law does protect gender identity and sexual orientation under the umbrella of sex, and requires same-sex marriage to be recognized across the US. So they've incorporated that in there, and it adds certain examples of harassment, including misgendering of a person, harassment based on appearance that doesn't fit a typical male, typical female. Now that there have been cases about that for a while, but now this is in the guidance. And again, not allowing a person to use a bathroom consistent with their gender identity. Not only do we have this federal guidance, but again, hopefully you're aware, we have a Colorado law on that also. And Colorado has protected sexual orientation and gender identity for longer than that Bostick decision. It also expands the definition of sexual harassment to decisions about pregnancy, contraception, lactation, and abortion. And it's the abortion portion of this that is causing, that is the main point of contention. And there is a legal lawsuit in place to challenge that portion of the regulation and whether that should be included, or excuse me, that portion of the guidance. So this is not regulation, let me be clear about that. And basically saying the EEOC abused its authority in putting that in there. The next one is actually a regulation. So these are things that are in place, and this is the regulations that were finalized to, CC, will you advance that slide for me? To finalize the Pregnant Workers Fairness Act. Again, the federal is lagging Colorado. We've had our own Pregnant Workers Fairness Act for some time, but now we have the federal act passed last year or passed in 2022, effective in June of 2023. And now we have regulations that take that law and distill it down to what you actually have to do as an employer. So this covers employers with 15 or more employees. So I know we have smaller employers in this group. It requires accommodations for qualified applicants and employees who have limitations based on pregnancy, childbirth, or pregnancy-related conditions. Of course, it allows for us as employers to get medical documentation to support any accommodation requests that the employee makes. And then we need to engage in that interactive process that we're maybe used to from a disability perspective in the pregnancy situations as well, to see what type of accommodation can be arrived at in the workplace. Again, there's another lawsuit. All of these things are being challenged, but the regulations are effective June 18th, unless they become stayed by the federal court, but they haven't been stayed yet. So some of the prohibitions in the Pregnant Workers Fairness Act that I just want to highlight. This is on the next slide, Cece. Are here. So some of these, again, they might be obvious to you, but I wanted to highlight them. So you can't just impose an accommodation. You have to discuss it with the person first. Okay. We can't deny job opportunities based on the need for accommodation. That makes sense. We're used to that in other civil rights contexts. We can't require employees to take leave if another reasonable accommodation could be provided that would keep them working. So that's sometimes a question I get from employers is, it's just easier for us to have them out than to do all this stuff in the workplace. Well, you do need to do that stuff in the workplace, and it's specific in these regulations. Also, you know, the usual, you can't retaliate against somebody exercising their rights or interfere. So the EEOC actually already began taking charges for Pregnant Fairness Workplace Act violations. They started taking charges when the law went into effect in June of 2023, and there have been some. And undue hardship now under these rules is still present. Like, we can say we cannot provide a reasonable accommodation because it would subject us to undue hardship, but that standard with these regulations has been raised to where it is in the Americans with Disabilities Act, which is that the employer has to show significant difficulty or expense compared to the bottom line of your organization. And that is a very high bar to be in place. So the next slide has some sample accommodations that they specifically put into the regulations. So I would look hard at these things if that's what your employee is requesting. One of the things that I run into with questions is the standing jobs, the jobs that, you know, require somebody usually to stand at a counter, and the employee is requesting a stool. And it kind of flummoxes me why we can't do that. Again, this is one specific thing that says you do need to do that if that is what is necessary for your worker. So again, this is all absent undue hardship, but these are example accommodations that come right out of the regulations. The last federal piece we'll talk about, and we'll take questions, is the Federal Trade Commission has finalized its rule banning new non-compete agreements. So non-compete agreements are agreements that you make with your usually high-level employees, and you basically require them, because they have worked with you in high-level positions, to agree not to work for a period of time if they leave you, or not to go to work, not to open their own business like yours, not to go to work for the competition, and, you know, significantly impact their business in the process. So those agreements have been difficult in Colorado for some time because of Colorado law. And Colorado, I think 2 sessions ago, set up a very high standard for non-competes in this state. But now the FTC is saying you can't have new ones with employees. If you have existing non-compete agreements, they're going to be void unless they're with senior executives that you can show meet this test of policymaking and this high level of annual compensation. You also get to tell employees, you know, that agreement we had you sign and maybe we paid you some money to sign, that's not going to be effective anymore after August 22nd of this year. This is not applicable to other types of restrictive covenants like those non-solicitation agreements. So you might say you can't poach our employees when you leave. So that's still good. That's separate. Confidentiality agreements that you can leave and you can work someplace else, but you can't take our proprietary and trade secret information with you and use it against us. So those confidentiality and non-disclosure agreements, as long as they are not so restrictive that they function as non-competes. So sometimes those are written so restrictively that basically the employee cannot work. So they function as a non-compete. So if you have those, take a hard look at them before August, because you may not be able to keep those. So again, there's another lawsuit challenging this one. We'll keep an eye on it and let you know what happens with it. I would say, all in all, the courts have shifted away from giving federal agencies as much deference with their rules as maybe they have in the past. And there actually have been some other Supreme Court decisions that have whittled away at the authority of the agencies when they take a law and make their rules about how far they can go with that. How much can they expand it beyond maybe what Congress intended, which is of course the argument that anybody makes against a rule or a regulation. So we'll see what happens. So we're at the midpoint. We're moving on to Colorado next. I've got the webinar chat up, and then let's see, there's a Q&A. Is there a minimum of sick time or PTO for exempt status? No. So Joey, that's the answer to your question. The exempt status is really the salary and the duties. So paid on a salary basis does limit when you can dock exempt pay. So that may affect, that may bring in PTO and time off that you have for your employees that is paid. So sometimes you have to fill in for their salary with those paid banks so you can make sure you're still meeting. But as far as a minimum amount of time, there's nothing in the Fair Labor Standards Act that says you have to provide any time off to your employees. We have, of course, Colorado's Healthy Families and Workplaces Act that requires us to provide paid sick time. Vacation is not required by Colorado or federal law, or paid time off if that's what you have instead. Other questions? Do non-competes apply when someone quits or is fired? It depends on how it's written, Blair. So sometimes, non-competes for sure when somebody quits, right? Because that's what that's what the business is trying to prevent, somebody from quitting, going to a competitor, and then taking all their, the value that they gave to that business to another business. So sometimes they will not apply in a situation where the employer fires the employee, like in a layoff or something like that. Does that really seem appropriate to lay somebody off and then prevent them from finding a new job? So it just depends on how that agreement is written. Right. Nothing else in the Q&A. Let's go on to Colorado. So there's Colorado session ended May 8th. There was a lot of activity, of course, as there is every session, but not as much employment stuff as we've seen in previous terms. And the governor has until next Friday, June 7th, to sign what bills he's going to sign that have passed through both houses of the legislature, or to veto them. And although Governor Polis hasn't done a lot of vetoing, there are a couple I'll show you at the very end that he did veto this session. And he can also just let them pass into law without his signature. So he doesn't have to sign everything if it's passed both houses. obviously he's a busy man, and he may not get to all the bills prior to that time frame. So we'll see what happens. So this one is signed and it is effective. So there is been some movement on the apprenticeship side of things. So there's different state programs where you can set up apprenticeships, and you might even receive some support from the state for those apprenticeships you set up. And now there's a tax credit that employers can claim. So if you have an apprenticeship program in your workplace, you might want to take a look at this because you could get some tax breaks on it. So of course there's limits that I didn't have room for on the slide. You can't claim for more than 10 apprentices in one income tax year. You can't claim for the same apprentice for more than 24 months, consecutive months. So you can get the tax credit for up to 2 years, but not beyond. And you can't claim the tax credit for months when you didn't pay the apprentice. But it is pretty decent if you do have an apprenticeship program. I would take a look at what tax credits are available. This next bill has the potential for being big. We just don't know yet. So this bill is bigger than employment, but it's to protect consumers in Colorado from discriminatory decisions made by artificial intelligence systems. So it will impact employment as well as other aspects of our lives. Now, the governor did sign this in the middle of May, and it's not effective until February 1st of 2026. So this is going to apply to organizations that deploy AI in their workplaces and organizations that design AI systems. So again, it's bigger and broader. It is being touted as the first of its kind in the nation as far as the breadth of this AI legislation. So Colorado's, again, carving some new ground here. It's following some of the AI state regulation that is out there, in that it is going to require an impact assessment of AI tools to monitor them for the potential of bias against protected groups. So we're going to those civil rights protected groups here. And it's going to require detailed notices to consumers who are negatively affected by an AI assisted decision. So that's a new thing that's not present. And the next item provides those consumers the opportunity to appeal decisions and seek human review of those decisions. That's another new thing that hasn't existed in the AI legislation or laws that have passed in other places of the country. So really, how big this is going to depend on the Attorney General in Colorado. So the Attorney General has been given broad rulemaking authority to implement this. So they've got until February 1st, 2026. So we're going to be talking about this at the next update probably. And enforcement. And our current Attorney General, Phil Weiser, has said that he anticipates, and I think this is what any Attorney General would say, that they're going to go after flagrant violators. So, the worst of the worst, and not the employer that's trying to use AI for innovation and efficiency and doing their best they can with the information they have and their understanding of how that AI tool works. So this one could be big. We'll see. We also had a bill that's not yet signed, but would be effective next year to raise penalties for child labor violations in Colorado. We have penalties under the Federal Fair Labor Standards Act we talked about earlier that are higher than this. But this would be layered on top of those penalties. And it ranges based on, again, the level of culpability. So willful violations are where we knowingly put a minor in a position where they could be harmed. So that's obviously going to be a higher number if the minor actually gets hurt by our willful action, versus a negligent action where we maybe knew or should have known better than to put a minor in that kind of role or using that type of equipment. So summertime usually is when we bring minors into the workplace when they're out of school. If you are employing folks that are under 18 years of age, you need to pay attention to the federal and state restrictions. And for those of you that are members, we have a pretty nice chart that compares the federal and Colorado restrictions. So there are different limits, not only on the type of work and the type of equipment that 14 and 15-year-olds and 16 and 17-year-olds can use. And spoiler alert, 14 and 15-year-olds can't drive for you. And they are more restricted. Also, what hours of the day they can work, how many hours a day, and how many hours a week they can work. So employers get more latitude, I guess, with the working conditions that they provide for adults. And adults, have a responsibility as well as the employer to look after themselves. But when it comes to minors, if there's a situation where a minor gets hurt or a minor is working after hours, it's almost always a penalty for that employer, not just a don't do this again situation. So again, they just got more costly. Next is on a restriction for collecting biometric data. So this is going to be beyond employment as well. So biometrics might include fingerprints, retinal scans, hand prints. You guys might know of some other things, Mission Impossible stuff, but now it's in our lives. So it will restrict permissible reasons that an organization can collect biometric data, but it'll allow it in monitoring workplace safety and in timekeeping, which is where I most often see this coming into the workplace. So it's going to set up a schedule, right? You have to have written policy for how you're retaining that information, how long you keep it. What do you do if that's breached? Somebody's fingerprint gets stolen and is used for fraud and employment or otherwise. And then destruction guidelines. So we have had restrictions on personal identifying information in Colorado that we have been following for years. So social security numbers, people's date of birth, their home addresses, those kinds of things. So their biometric data, I would imagine, will have similar protections to what we have dealt with and done well with on the personal information side. We've also got a bill that passed this session to protect living organ donors. So this is specifically in employment. It's going to prohibit employers from intimidating, threatening, coercing, discriminating, or retaliating against individuals 30 days before or for 90 days after they become a living organ donor. So I don't even want to know the stories that caused this bill to have to exist, but it exists. So it does specify that employers are not required to provide additional paid leave or unpaid leave beyond your existing laws and policies for organ donation. Then we've got a bill to limit recovery of education and training expenses. Again, I've indicated the last few are not yet signed. We'll see if they get signed in the next week. But I don't think they're going to be vetoed. We'll see. But this one is about those agreements. We bring somebody on board, we pay a lot of money to get them certified in a different program, or it's usually specialty fields. We get them trained. The last organization I worked with had linemen, right? It's an expensive process because those people have to be very knowledgeable about what they're doing, because there's a safety risk involved, and it's costly. So if you have a agreement with those employees for recovery of those education and training expenses, then we're going to soon have some rules, again, from the Attorney General on what those limits on how we can recover are. And I mentioned Colorado's non-compete statute. One of the changes to the non-compete statute, I would say a couple years ago, again, to make that even a higher bar, also limited recovery of education and training expenses to like a maximum of 2 years and a prorated situation. So you had to basically prorate it by the time. So you would have reduced recovery for the time that the employee spent working for you. So it's a diminishing return situation. So you'd have to, if you have these agreements, you're going to have to look at the Colorado non-compete agreement limitations, and then what rules the Attorney General comes up with here. Some of you might remember the Crown Act, which passed again 2 years ago through our Colorado legislature, that added to the Colorado Anti-Discrimination Act a prohibition against discrimination based on hair style that is associated with race, typically or historically associated with race. And there were a number of different types, right, of protections, traits that were put in to that statute at that time, but hair length was not one of them. So this session, hair length was added to the traits that, again, are commonly or historically associated with race. So we have that added. And I don't, again, anticipate that that'll be vetoed, because that law is already in place, and it's just adding another component to it. Other updates, there's a bill again to establish a uniform process for different occupations that have registration or certification requirements for how you consider criminal records in that process. So they'll allow a regulator to consider an applicant's conviction of a criminal offense if it's a violent felony or a violent misdemeanor. If it's an offense but not violent, then there's going to be a process for whether it disqualifies the person. So this isn't on the employer, but you may be hiring people in professions that are regulated, and it'll be on those regulators for how they factor that in. Colorado legislature can't leave workers' compensation alone. So every year there's some change to workers' compensation. This change will allow a worker to refuse light or modified duty if driving to and from that light or modified duty is required and their physician has restricted the employee from driving. Again, it seems like, I don't know if we feel like that's needed, but they did put that in place. And then two others, there was a bill passed to create a Colorado Disability Opportunity Office that will be a resource for employers and other organizations on disability issues, and will be an advocate for inclusion of disabled workers or disabled persons in the different opportunities. I'm assuming including the workplace, because the numbers for unemployment amongst disabled individuals are somewhere near 25% whenever I read them in an article. So when you're thinking about historically low unemployment, not just nationally, but in Colorado, which is still the case, the it seems to make sense that we would look at all avenues where we could find those workers that we need. And then lastly, there was a fixer bill. Those of you who are public employers know and love the Colorado Open Records Act. That's the act that regulates what public records the public get. Often it's the press, but sometimes it's a employee of a public sector. They can get access to certain things. When the Power Act passed last year, that was the law that changed the standard for sexual harassment in the workplace, took away the severe and pervasive requirement. It also set up a repository that all Colorado employers must keep of records of complaints and investigations of harassment and discrimination under the Colorado Anti-Discrimination Act, as well as accommodations that you make to individuals under religion and disability, and now pregnancy. So these two laws didn't work together well because CORA had its own set of definitions of what is a public record and what is disclosable in what situations. And then the Power Act had all these new record keeping requirements that employers had to have. So they reconciled those to allow records pertaining to sexual harassment complaints or investigations of elected officials found culpable for sexual harassment to make them accessible under both laws. So there was no question of whether, so they weren't fighting with each other anymore. So somebody couldn't say, well, I'm entitled to it under Power, and then the public entity say, but you're not entitled to it under CORA. So it resolved that dispute. Last slide is a couple of bills that were vetoed by the governor. So one would have amended our wage theft statute specifically for construction employers only, and would have required subcontractors to notify general contractors if they received any wage claims. And the governor said, he's worked really hard to crack down on wage theft, but this bill would have done little to prevent wage theft, and it would have unfairly punished, the GC maybe for a subcontractor's actions. So he vetoed that one. And then the last one is a bill that passed both houses concerning the Sunshine Law. So public meetings and when political or religious topics were discussed in those meetings. Oh no, I'm sorry. It's not public meetings. It's employer meetings. So I apologize. Scratch that, rewind. It concerned employer meetings. So this is workplaces. If employers have required meetings with their employees of a political or religious nature. So sometimes employers want to impart their views on certain things to their employees. It would have prohibited employers from taking adverse action against employees for refusing to attend or participate in those meetings. So Governor Polis said in vetoing this one that the definitions of political matters and religious matters were too broad to be workable. So he didn't like the bill. We'll see if it comes back in the next session, but he vetoed it. So let's see. We don't have any open questions in the chat or the QA.
Kim has her hand up. So Kim will try to allow you to talk. So just be ready.
Or can you type? Okay. Yeah. Go ahead, Kim.
You're muted.
Sorry, I raised my hand by accident. I'm good. Thank you.
Okay.
No.
All right. So again, hopefully you're getting the sense that it isn't as much drama or change for employers this session. I think that AI bill will be, well, that it's now law because the governor did sign that one. I think we'll keep a close eye on what the AG's office does with that. And that will, for those of you who are starting to use it, or maybe you don't even know you're using AI, but you are using it, at least rudimentary forms of it every day, probably. We'll see what we have to do there. But that's probably the biggest, that and the federal overtime threshold. So if you have questions about that, make sure you reach out to your legal advisors, to your HR. If you have general questions, Cece can send them to me and I can answer those and send them out to the group.
Perfect. Thank you, Tina. If you guys have any last questions, you can go ahead and put them in as I'm kind of giving my closing spiel. But I will be sending out the recording and the slides this afternoon, so you will have those on hand. If you are interested in anything else about the legislative session, so not a deep dive into business stuff, but just a general overview, we are working with the Mountain Chamber Alliance and 5 of our legislators to put on a session on June 6th during lunch. I'll send that information in my follow-up email. And then we also have the Empower Yampa Valley Conference coming up on June 27th, which is focused on progressive policy, HR, and DEI. And I can send a link for that so you guys can look into it too. But I just want to thank everyone for being here. Thank you, Tina. We'll see you.